Welcome to the Extra Mile podcast for bar exam takers. My name is Jackson Mummy, and each week we'll be bringing you updated information about the bar exam and what you need to do in order to make the next bar exam your last bar exam. Ready to get started? Let's jump to it. Welcome. Today is Wednesday, January 25th, and we are so glad that you are with us. I've got June here. She's got some things to talk about with group coaching and some other announcements. I've got Brianna here, and good to see you. And post-trial, glad to have you back with us. We have Judge Dawson here with us, so the view from the bench. Good to see you, Tracy. And you and I are going to be talking later today. We announced last week that we've got a boot camp scheduled for May, I believe it is. I think it's May 19th and 20th. And it's going to be here in Denver, which is pretty exciting. And we've got the information up on the website. There's the opportunity to reserve your seat with a small deposit, which is fully refundable. We're only going to take 15 students again because we did it that way last time and it was really good. And just check that out, but secure your seat. With only 15 seats, we're going to sell out and you'll get closed out. Make your deposit, hold your spot, and it's going to be 2 days of learning to photo read and applying photo reading and mind mapping and mindset coaching. June's going to be there. Tracy's going to be with us. We got a lot of stuff. We're going to bring in some guests, and we may even steal Brianna and Amanda via Zoom for a bit. So there's plenty going on there. But boot camp, if you're a July bar taker, that May boot camp would be just perfect for you and would encourage you to attend. With that, I am going to jump into the questions and let's see what we've got, and we'll bring the panel in here to talk. First question was a pretty straightforward one. The student wanted to know whether we offer test prep for the South Carolina bar exam. South Carolina is the uniform bar exam, and so yes, it is covered. This student said, I've been preparing for Georgia, but wondering if you offer test prep for South Carolina. Would you recommend taking South Carolina first instead of Georgia? It's a good question. I think you should take the UBE first, but I want to flip this over to Brianna because she did take the UBE and has used that pretty successfully, I think, right?
Absolutely. And remember, many years ago, I also took the Texas bar before it
That's
switched
right.
over to the
That's right.
UBE.
Yeah.
And I think if for any reason, I think taking that UBE is going to give you a sense of confidence going into the Georgia bar. And yes, I think the UBE is enormous. If you don't have to be barred in a specific state, take the UBE.
Yeah. Speaking of the UBE, I had a lengthy conversation with one of the members of the National Conference of Bar Examiners, and it was a great conversation. And I'm very appreciative that they talk to us and work with us and are as cooperative as they are. We were talking about a couple of things with the UBE and the MBE as well that this is probably a good time to talk about. The first was there's obviously been a lot of concern about the decisions of the Supreme Court in the last term and what impact those would have on the multi-state and on the essay questions. And I'm thinking specifically about things like the potential changes to the Lemon test, Hobbes, and the changes around Miranda and some other things. In any event, the NCBE representative basically said, we're not going to put those things into this exam. It takes us a full year, in some cases, a couple of years to get questions ready. And so we're not testing those recent decisions. And I asked, well, what happens if there's an answer choice in an MBE question that might implicate that? And her response was, we would just simply throw that question out. We've got additional questions available. And there's 25 questions in each exam that are designated as evaluation questions. So we just slip one of those in instead. So my point is, you do not need to be conversant in the most recent Supreme Court decisions. Now, if you know them and you want to write about them in an essay, that's fine, but it doesn't sound like those topics are going to come up. So I wouldn't expect an abortion question in the essays, for example. I wouldn't expect same-sex marriage. I wouldn't expect anything that really touches in those sensitive areas of the court's decisions. And I think that's good news. I think that the NCBE is taking the right approach. Having said that, I also have to say, if you're taking the bar exam in California, Georgia, or Florida, that's not the NCBE, and their state essay questions could be anything. And so unfortunately, you probably do need to be aware of those distinctions because we don't have any direction or guidance from those three jurisdictions. But I wanted to wrap this around because I think to Brianna's comment about Texas or Georgia or any of these other states, the idiosyncratic states are much more difficult to deal with than UBE. And so if you've got a choice, if you're listening to this and you have not yet decided on a bar exam jurisdiction, let's say for July of 2023, I would absolutely go to the UBE first. It gives you the opportunity to get potentially licensed in 40 states. It's New York, it's Texas, it's a bunch of places, and it's a better test. It's a fairer test, I think, than Florida, California, or Georgia. So I think it's just valuable to be aware of that and understand if you've got those choices. And I think it's also good to recognize that the national conference is trying to keep the test as equitable as they can right now. One final comment about the bar exam writ large. You've probably been hearing about this thing called the next generation exam coming out maybe in 2025, 2026. It also appears that the examiners are going to have a transition period of a couple of years in which jurisdictions will be allowed to choose between the old exam, the one we're giving today, and this next generation exam. And that shouldn't impact anybody that's listening today, but I just wanted to say, don't freak out about it. We've got it under control. We know what's going on, and nothing's going to happen for a while. So there you go. All right. So that's my riff on the UBE and the NCBE. All right. Next question that we've got was talking about a product called bar maps. This is the time, I think, when bar maps become really valuable to students to use. And I think this is a good time to be doing that, right? If you're feeling a little lost or behind on mind mapping, bar maps gives you the mind maps for every subject in your state exam as well as the multi-state. And we really encourage that. I think it's a good way to get it. The value of mind mapping is pretty great, isn't it?
Absolutely. And I was pleased to see that you were offering that as part of the program when I turned over to become a coach, because that is essentially how I would set up my mind maps. I would use the outline of the lecture or the table of contents for the outlines for each one and give me a starting point. So I think it's enormously beneficial to have that as something you can purchase as an add-on to save some time. But mind mapping gave me something to do instead of just do the mindless task of taking notes.
Yeah.
I think taking notes is incredibly useless. You're really not going to, even if you go back and read them, it doesn't give you a different way to look at the content like a mind map does. It gives you a visual representation that it gives it another version of how your brain can take in the information. So I think if you can dive into mind mapping, you should absolutely take advantage of it.
Yeah. And one of the questions that comes up at this point, people say it's time consuming and we're at 27 days to the bar exam. Do I have enough time? The answer is you don't have to mind map everything, but you should mind map the subjects that are difficult or the parts of subjects that are difficult. And a product like bar maps just gives you all those mind maps immediately. And then what you want to do is take those mind maps and read them out loud and really engage and work with them and add to them yourself as you're going through and doing multiple choice questions or essays. So I think it's a really valuable product to have at this particular point in time. Again, available to all of our students and available to the public as well. A good product, I think, to be using.
Hey,
Okay.
Jackson, we have a
Yeah.
question that might
Yeah.
be in here really well.
Yeah. Go
Um,
ahead.
so the question is, I registered for the course late. I started from the subjects I hadn't covered. Is it
Mhm.
beneficial to go back to the MBE subjects I haven't covered, or should I go directly to the review session?
I think you could go to the review section. It's a hard question for me to answer. I'll ask Brianna as well, but I think it's okay to go back to the review section and recognize that there may be gaps and things you don't know, and that you're going to want to either mind map or, again, in bar maps, there's the timestamp video lecture, so you can find the part of a lecture where you need the information. I think the idea at this point is to not go wide with your study, but to go deeper on the things you don't know. What's your thought there, Brianna?
It sounds like they're talking about the mind mapping specifically.
I think what they're wanting to do is just the review. So basically, the subjects they haven't covered, would it be beneficial to go back to MBE subjects and cover them, or just go to the review sessions where they could possibly be covering them there as well?
I think I agree with Jackson. I think you go straight to those review sessions. And then if there are problem areas you've got, then I think you go and dig deeper into that specific area at this stage.
Yeah. You really want to work to your weaknesses right now. And if you've covered something, don't need to recover it or go over it again. You find out what you don't know and then work in there and go deeper. And I think when we get into this 30-day window, to me, it's it's probably more valuable to take birds on the wire and knock them off. Here's something I don't know. Here's something I don't know. Here's something I don't. Rather than trying to say, I want to study the entirety of the subject again. Because most of it you probably know. And I think you want to be careful with your time. We're going to talk about this with Tracy later today. Don't waste your time. Don't waste anybody's time when you're going through this. So that's my take. I hope that answers that. So next question that I've got, and we get this question now, I get this about every day, multiple times a day. What's going to show up on the upcoming bar exam? What are your predictions? Brianna's laughing. And I hate this. Many years ago, when my hair was naturally dark, I did what I call prediction emails, and they became very popular. And I had a very good track record. And suddenly I found that people were actually selling my emails out on the gray market. And I thought, this is dumb because I don't have any inside information. Anyway, it got way out of control and I stopped doing an email and I said, all right, I'm going to start doing videos that I call previews, not predictions. So I don't know what the distinction is, honestly, but in any event, it's a look back at the last exam and it's a little bit of a look forward to where I see the trend lines on the exam. I do a video for California, Florida, Georgia, and the UBE. Those videos come out typically between the 1st of February and the 10th of February. I give myself a little bit of wiggle room there. And we will put those up in the course platform and put them out there. But I think it's also useful to talk about how valuable is it to have those previews or predictions. Brianna, you want to talk about that a little?
Yeah. So I think that it is very valuable to take to the exam with you as a secondary piece of information. While Jackson's predictions or previews are generally they're very good, you need to be prepared for everything that could show up on the exam. So I think up until you get that video from Jackson, you need to be studying as though that video is not coming. You need to be familiar with all of the topics and keep going as if you're not getting that video. I think it's great to be able to focus those last 2 weeks. Maybe let's say Jackson gives you an idea that something might be on the exam that you feel is maybe one of your weaker areas. Go in and do a deeper dive on that, pick up some extra points in that area. But I think that's probably the most useful thing you can gain from that video Jackson will put out there.
Yeah, I think that's really the way I'd like it to be used because because no one has any inside information. No matter what you're hearing out there, nobody's got inside information. And it could be distracting to you if I say domestic relations in a particular state, and you go, oh, I gotta go. Maybe it's there, maybe it's not. It's only really valuable if you've got a weakness in that area. And then I think you do what Brianna said, you dive in a little bit and say, okay, more likely. I What I do is I watch the trend lines, I talk to the examiners, I try to get a sense based on my own experience of where I think the exam is going. But there are some really wild things that happen. I'll just remind some of you that last exam, right before the exam, Florida announced all of the recent Supreme Court decisions are testable and the Florida new rules are testable. And then they didn't test any of it. That was just weird that they did that. But I think that you want to be ready for anything and you want to be confident about all of that. And then we're just going to try and give you some sense of where I think the exam is headed. The good news is the UBE looks pretty stable and solid to me. The bad news is California, Georgia, and Florida are pretty volatile. And so I think we just take a tight grip and hold on and make sure that we're prepared for the basics and go from there. And I think that's about the best you can do. So there you go. All right. Next question that I've got is an administrative question. Student failed in July of 2022 and wanted to retake in July. And they asked if they'd have access as a retaker to the course. The answer is yes. We have a lifetime pass guarantee. Once you're registered in this course, you stay in the course until you pass. Now, having said that, I absolutely believe what I say about doing things differently. So if you're in the course and you didn't pass, we're going to make recommendations about what you need to do differently. And sometimes people are like, oh, I don't want to do it. What's the point? If you're doing the same thing over again, you're going to get the same result. So we may say, we want you to do coaching with Brianna or Amanda or Tracy or me, or do mindset coaching with June, or add photo reading, or whatever the resources are. not because we're trying to sell you more stuff, but because you got to change what you're doing. And Brianna, you went through that process. You took the exam, were not successful, and then you had to do things differently in order to be successful next time.
Absolutely. A part of it was going all in and accepting that I couldn't do it by myself. And just because we might recommend additional resources, it doesn't necessarily mean you're not as smart or you're not as capable. You just have to remember that you're on your own journey and your own path. And maybe something will click for you if you do something a little differently. I used to love Jackson's comment on the definition of insanity, just doing the same thing over and over again, and expecting different results. You can't do it that way. You're not going to be successful that way. Yes, I did things different. Investing in yourself. We talked about that last week. Yes. Don't look at it like we're trying to sell you a new product. We are trying to help you invest in yourself so you can be successful on the exam.
Yeah. And along those same lines, we got a question. The student said, I'm going to need coaching for California. What are my mentor coaches' choices? And the mentor coach choices there, if you're retaking or if you're taking for the first time, are me or Tracy. We've done it that way. We've set up the UBE with Amanda and Brianna or me. Tracy, let me bring you into the conversation here. You're starting to do some of this California coaching for us. You having fun doing that?
I love it. I love it.
Yeah.
I love inspiring people to find their best self and to put it forward. And that's really important for California because it's daunting because you hear all the time, it's the hardest test, it's the hardest test, it's the hardest test. But you know what? It's just California's test. And don't psych yourself out. Just get ready for it. And I'm going to talk about that more in a few minutes.
Yeah. People ask, what's the difference between working with me or working with these others? The truth is, I look at the work that comes in either way and consult with our coaches before they talk with you. And we record those calls and I review them as well. So you're not missing out on anything. I promise you're getting, I think, a wonderful perspective. And that's why we've asked these three very talented coaches to work with people. So encourage you to do that if you are interested. There is space available. If you're a July 2023 student, I want to just say this is the time that you should be registering for the coaching with Brianna or Amanda or Tracy, because there is the capacity to handle that. And you're going to find life is a whole lot easier if you start early, Brianna. Future self is going to appreciate it a lot.
Absolutely. The earlier you can get started, the earlier you get through that substantive and into the review where you're actually going to get all the work and all the bonus points that you can find. So start early and start your coaching early. I think I probably, for the February bar, I probably had my first call with Jackson maybe in June of that year. And my schedule is not your schedule. So don't let that freak you out in any way. But yes, the earlier you get started, better.
Yeah, I think so. And you can register and then you'll have a special calendar. Each of our coaches has their own calendar and you set up your call with them. And again, we record those calls and be able to go back and go through them. So encourage you to do that. And also just reminding you that Brianna is offering the personal writing workshop, which is a 2-call session. And that's a great opportunity, isn't it, to learn the mechanics of the writing.
Absolutely. If you find yourself struggling with FLA, definitely schedule a call. Like Jackson said, it's just a 2-session. We'll have one where we will talk about your writing and I'll assign you an essay. And then we'll do the second one and we'll break it down and really hone in on some of those skills.
Great. Good. Then along those same lines, somebody said, I see that you offer something called Basic Plus coaching, personal coaching, premium coaching. What are the differences? It's just the number of coaching calls. In Basic Plus, it's 8 calls with me. In personal, it's more than that. And in premium, it's more than that. I don't even know anymore. But how can you upgrade to that? The best way is either in the Upgrade Center or by sending an email to June, and she can give you the correct link for the coach and the number of calls that you want. But that's the only difference in those options. All right. Next question, which was also a bit of this student said, I really like the lecture transcripts are helpful for me. And what they're talking about is when you watch a lecture, you see the text of the lecture up on the screen. And they said it's helpful for my notes and mind mapping. That's the idea. That's what we want it to be. And they said, are you able to send me the PowerPoint or another text format of the lecture transcripts? And the answer is no. This is proprietary, copyrighted information. And unfortunately, we know that once we release that as a digital file, it's out there in the wild, and we're just not going to do that. But more importantly is we put it up on the screen. You can always stop the screen, take your notes. I think that's more valuable than having the entire text. And obviously, I'm reading a lecture, I've got the text, but I found that when people see the whole text as a big document, it's just too much information. It just blows them out. Brianna, you're smiling. It's more than the person needs.
It is. It absolutely is.
Right.
And what I think the takeaway that you need to use with the actually having the transcripts, which I think is enormously beneficial, is you're hearing it and seeing it at the same time. So if you can pull yourself away from that desire to write things down and just focus on looking at the transcript as you're hearing the lecture, you're getting everything that you need.
Yeah, I think that's the design. And you don't want to overdo it, right? You don't want to have so much data that's, I don't know what to do with it. And
At that point, you may as well go and read the outline.
yeah, pretty much. Next question. This is one that I know, Brianna, you discussed in your group call, but I want to take it out to the broader group. And it had to do with if you're in an essay and you have a dispute that you need to discuss, right, and call the question, and you forget what the rule of law is, what's the best way to handle that? I'll throw it off to you since you discussed it last night, and then I'll pick it up after that. So let me give it back to you.
Yeah. So I think it's no ways that you are going to get a question that you don't know the answer to on board. So instead of going into freak out mode, the one thing that I really recommend with my students who jump on my group coaching calls and to all of you is to take a deep breath first and foremost. You are very capable of answering every question that's thrown at you. Pay attention to that rule or pay attention to the call of the question and try to identify your conflict here. Try to identify, okay, what's going on here? Who are my parties? And who is going to want this thing to happen? And then who's not going to want this thing to happen? And identifying them first and foremost and how they show up in the fact pattern is really going to help guide you. Now, in that, forget about the fact question or fact part of your outline first. Go straight to the bulk of it where you identify party A wants this. Why do they want it? And then party B doesn't want it. And why don't they want it? And then go back in and make up a law if you have to for right now. Make up a law that would support the way you believe and your gut tells you it's going to turn out. So I need those 4 sentences, right? So you've got party A, you've got the law, you got party B, you got the law. And then go ahead and write out your conclusion sentence. And then if you can get 1 or 2 sentences in there describing it, great. And then go back in and see if you can address the facts that go at the very beginning. More often than not, approaching it that way is going to guide your gut instincts to come up with the correct rule of law, even if you're not regurgitating it verbatim onto the page.
Yeah, I think that's right. I developed the FLA writing system 35 years ago as a way for students at Georgetown, pretty good school, who just didn't know the law. The reality is that they just didn't know the law and couldn't know all the law. And so what do you do when you don't know the law? You ask what my mentor called the guiding question. And the guiding question is what's in dispute. So you find what's in dispute. And then you ask yourself, what would the law have to be to support this argument that I'm making? So when you see the dispute, when you see the problem, you just look at it and you say, all right, what is party A going to ask for? What's party B going to ask for? What's the law have to be to support their position? And I might be making it up entirely for those 2 parties, but by doing that, what I'm doing is I'm creating a boundary, a hedge of where the law is. It's almost certainly between those 2 positions, somewhere in there. And examiners are less interested in you being able to recite the law. They're not interested in that at all. They're interested in the way you reason and the way you think about it. And so you pick your choice and you explain your reasoning, you're going to get some points. Now, I want to caution everybody. You cannot go through all of the essays on all of the bar exam and not know any law. Doesn't work that way. But you come with a great deal of knowledge already. And I said this in my daily email the other day. You already know enough law to pass. We're just trying to get you to be able to produce it, put it out on test day. And so because of that, there may be, let's say you're in a 6 essay UBE exam, and there are 4 calls of the question on average for each of those. So there's 24 points of law you're going to be tested on. I think it's likely that there are going to be 4 or 5 of them where you really don't know the law. Does that seem reasonable to you, Brianna? It's probably 4 or 5 there.
Absolutely.
Yeah.
Yeah.
Yeah. And if there are 4 or 5 you don't know and you use this hedging method that we talk about, you're going to get some points and you're going to be okay. And so the reality here is that you can get away with it. Now, if you didn't know 24 of the 24, that's a different problem. Okay. But there are going to be some things you don't know, and then you're going to have to deal with it. And you're going to have to juggle. And I know Tracy's going to talk about this because she's seen lawyers do this all the time. Go ahead.
Yeah, I think the thing is you fake it till you make it. So you get in the question, as Brianna is suggesting, and you write what you do know about. And you just let that to be a very robust answer. And more often than not, something will come to you that is intuitive, as Jackson was saying, what should the law be? And then you might remember from your mind maps, and you might be able to throw in the right words that do it. I did it many times as a lawyer. I didn't go in every case unprepared, but every once in a while I was unprepared, and you fake it till you make it. But here's the thing. If you have these 24 questions or whatever, and you are showing the bar examiners the same type of pattern every time, they get to question 8 or 9 or whatever, and they're seeing the same kind of pattern, you're more likely, if that pattern is consistent, to get a pass on that than if you are all over the map for your entire test and you're just exhausting for these bar examiners to look at it. Stick with the FLA. Use the same process every time. And if you get in one where you're kind of fake it until you make it.
Yeah. I think
Can I,
it's
can
pretty
I just
much.
add real
Yeah.
one point? So I love that advice. I tell everybody on a regular basis, like, they're like, you seem so confident. I'm like, they can tell you make it. But also keep in mind that it's so easy to get consumed by the fact that this is a test, that some of these questions aren't out of the realm of possibility of a client like that coming into your office with the fact pattern. And the bar examiners are really just trying to test you on how would you advise them?
Yeah.
How are you going to explain how the law works? And because most of them don't know how the law works and they get very frustrated when they see how the law does work. So you have to remember and take a step back that they're not, yes, they're testing rules of law and it is a test, but look at it big picture. How are you going to advise your clients and whether or not to move forward or not move forward? What's the likely outcome?
Yeah. And every time I talk to the bar examiners, I'm reminded that they're just people. They're trying to create a fair test, and don't assume that they're trying to screw you over. And you can talk about the law that would make sense to support an argument and not worry about, oh my God, I didn't have the black letter law memorized. I didn't have 100 flashcards. I didn't have all my mnemonics. I didn't do all that. It's really wasted energy. And we're going to talk about that with Tracy here in just a minute. But I think it really goes to that point of just being in it and giving your best answer and trying to answer it and faking it if you have to on those parts. Great question. We got it. Another question that I know you dealt with in your group call last night, Brianna. We had a student that's had some surgeries on hand and wrist and arm, and they can't do any typing or writing for a while, but they want to keep studying a little. And they said, what do you recommend? What's your recommendation? I'm curious to hear what you had to say about that.
Yeah, so my recommendation was to keep going as though she was going to be taking the February bar exam to the best of her ability. So if she could do multiple choice exams and circle those answers, go forward with that, finish your review phase. And then when you're practicing essays, I believe that she will be utilizing some dictation software to start practicing that immediately. And just up until the surgery, continue as you are. Don't and get through that material. That way you can almost start from scratch, start from the beginning when we're on the other side of the surgery in preparation for that July bar exam.
Yeah, one of the things I would do is I would take the bar maps and the mind maps that you've got, and I would start reading them out loud and recording them. I've had students telling me that they followed that particular advice and they take the recording and put it on a loop on their phone at night, put the phone under their pillow, or I recommended at boot camp something called Sonasleep. It's this bar that you put under your pillow that only you can hear. So your partner in bed can't hear it at all. It's great. It's a Bluetooth device. And they just put it on a loop and you just play it back and listen. So I think you can do a lot with that. I think as AI gets better and better, and we'll probably talk more and more about this. I was just asked to do an interview about the chat AI that are out there and taking the bar exam. But as those technologies get there, it's easier and easier to dictate, and the accuracy is better and better. So I think you can do a lot of things without having to type or write. But I do think the general advice is, if for some reason, if you've been studying for February bar and we're here in this 1 month window, and of course, this is, June would tell you, this is when people start postponing, right? They say, I'm just not going to be ready. And that's fine. In our course, you can postpone without reason. You don't have to give us a reason, and there's no cost, as often as you need to. Okay. So this is a judgment-free zone. If you decide not to take the February exam, that's fine. The key is, don't stop studying though, because it's when people stop studying and they're X number of days till the bar exam, there's something about human nature that we wait until we're that same number of days to the next test before we start again. So don't make that mistake. If you're going to stop studying, if you're not going to take the February exam, keep studying. Is that the advice, Brianna?
Oh, absolutely. I love that idea. Yeah, you're absolutely right. So keep in mind, like when you're going after a goal and you fall off the wagon, it takes that much longer to get back on. So absolutely keep studying, do what you can for as long as you can, and then regroup and come back to it in preparation for the July bar as soon as humanly possible.
Yeah. I've got one more question I want to cover before Tracy and I go into our discussion. Had a student that said, I'm going to handwrite the bar exam. And what advice do you have for someone that's handwriting? And I'll just start by saying, if you have a choice, if you've registered to type, you should type. Yeah. Unequivocally, 100%. The bar examiners have a bias against handwriting. They tend to see it as either you're old, poor, or you're tech phobic. And none of those things are positives to them. Now, there are some circumstances in which, for medical reasons, primarily, people say, I'm just going to handwrite. If you make that decision, that's fine, but recognize that you're probably coming in at a disadvantage. You're not going to get as many words on the paper. You're going to have to be much more careful with your organization, because you cannot, this is one of the things that Tracy could probably remember this back in the day because she had to handwrite her exams, but you cannot insert things. You can't scribble. You can't make a mess of the page, because these readers are not used to seeing handwritten work. They're used to seeing typewritten work. They give 5 minutes basically to read each essay, well, a little bit less in some states now. And if they see a mess of a paper, whether it's a performance test or an essay, you're done. So you got to be really thoughtful about what you do. I produced a video for this particular student talking about some suggestions, but mostly they're things like print your headings, organize, leave a little bit of white space between sections. You can't go every other line. The examiners won't let you do that. There are actually page limits. And really, if there's any way you can type, even if you're a slow one-finger typist, type. Now, it's too late to register to type if you haven't done so. But if you're thinking about the July exam, register for it, practice your typing, and you can always handwrite on the exam day, but you can't go the other direction. So that's the weird part of it. You want to add anything to that, Brianna?
No, only if I don't know anything about this particular student, but if you're going into handwriting something right now, just remind yourself that you're going to be typing everything as an attorney. So if it's any kind of fear, get used to it now. Everything is electronic these days. We're all e-filing. Everything is electronic, and it's all usually typed.
Yeah.
The earlier you can get comfortable with typing everything, and I wouldn't even fathom. My handwriting is horrific. If I had to handwrite my exam, I would fail. So
Yeah, it's a challenge and it can be done, but make sure you're practicing. If you're a handwriter, practice and practice under time conditions, practice with the book closed. I said to this student, you should be sending me your work. You should be getting coaching, because somebody else is going to have to look at your work and tell you whether it's readable and makes sense, and if you got enough words out there. So I think that's one of the challenges. There you go. All right.
Okay. I think the other thing is that most handwriting is gender identifiable too. So you are giving the bar examiners information that they should not have. And there can be implicit biases against you with that. And if your spelling isn't good, if you have a lot of erasures and cross outs and all that, it just looks like you don't know what you're doing.
Yeah, it's really got to be extreme if you're going to handwrite. It's got to be a really good reason. So there you go. So you're not getting any love for the handwriters here, I'm afraid. It's the reality. All right. Thank you for these answers to the questions. We wanted to save a little bit of time. I've been trying to think about how to discuss these conversations that Tracy and I have been having these last few weeks, and I thought we should just call it the view from the bench. And then Tracy appropriately showed up, the Honorable Judge Dawson, with her robes, and you got all your stuff, right? Yeah.
I
Look
have
at
all
that,
my
man.
stuff. I have
Yeah.
my gavel. I have, and this is not to be funny, although it is in a way, but it's to give you a visual when you're practicing writing your essays. I want you to have this visual in mind because actually what you're doing here is learning through taking this class how to write and how to present in a court, in a tribunal. And that's what you need to think of the bar examiners as, not as a professor in law school, but really now as professional judges, what you're saying. I said to Jackson that the topic for my time is don't waste my time. Got this in the chat for you so you can capture it too. All right, a few don'ts for don't waste my time. I absolutely hated it when attorneys came before me and wasted my time. I had X number of hours to handle more cases than was possible. And the last thing I needed was someone stumbling and bumbling around or misquoting the facts, and massaging the facts to create the result that they wanted, or trying to assume that I knew things that they were too lazy to present or didn't know. So the first thing is don't waste my time. You have an hour to write a clear, cogent essay. Use FLA. Don't waste your own time. Make every word, make everything that you're putting in your essay count. Secondly, don't assume I know what you mean or what the law is that applies. Now, that kind of goes hand in hand with fake it till you make it. If you can't remember what the law is, but don't assume that the bar examiner is going to fill that in for you. At least give enough if you can't remember what the law is to bring the bar examiner along with you as you would do with a judge. I think if you do that and you do a good job on the facts and a good job on the dispute, the law will probably pop up to you if you've done your work. It'll probably pop up to you from your mind maps. But don't make assumptions that the bar examiners know what you mean or what the law is that applies. Don't argue the case by massaging the facts. That is a sure bang loser when you change the facts to make them the way that you want. Go back, check your facts against what you've written that your facts are, and make sure that they agree. Because if a bar examiner picks up on that, it's deception and you're not going to get points. And they're going to be looking for that then in your other essays. On the other hand, don't waste words. Don't put in a bunch of superfluous stuff that doesn't matter. Go to the heart of the matter. What is the heart of the matter here? What is this dispute really about? Tell me. Bring that to me so I know where you're going to go, and make your words count. I think, and this may be a little bit different than what Jackson teaches you, but I think you should write in present tense. Not A will prevail, but A prevails. I think you should be an advocate the whole way. B loses. A argues. B counters instead of they will, they might, it's probable, it's likely. Don't be wishy-washy. Just get in there and be the advocate for the position and be respectful for the position that you are rejecting, and tell me why. Tell me why. Don't just ignore that and assume that I know why the other position should not win. Tell me why. And
Yeah,
then fourth, and then I'll be quiet, I promise. Don't waste opportunities to lead me where you want me to end up. So in your headings, for example, don't write, for instance, in one that I was working with yesterday, don't write mailbox rule, right? The mailbox rule applies, or how the mailbox rule applies, or how the mailbox rule doesn't apply. In your heading, let the bar examiner know where you're going, and then make sure that what you've written below it agrees with what your heading says. You're just wasting words if you just put up part 2, part 3. Okay. What does that tell me? Nothing. So I don't know, Jackson, I may have just stepped over the line here with what I'm
No.
saying, but this is what,
Mm.
as a judge for 33 years, this is what I wanted to see. And this is where how people won their case in front of me was being prepared, using the words that they needed, being absolutely spot on with the facts, no funny games there, and definitely with every word leading me where they wanted me to go.
Yeah, no, I agree with everything you said. I think making every word count is particularly important here. Brianna knows in a UBE essay, we're looking at about 750 words. If
Was a
those
lot.
words, yeah, if you're making every word count, that's perfectly sufficient. It's when you start wasting words and talking around things and talking in passive voice versus active voice that you get in trouble. And I think everything you do should be leading the reader to understand how you're resolving a problem. And so I love the idea of headings and first sentences and conclusory sentences to wrap up and show what you're doing. This is particularly important in the third paragraph in this writing style. That application paragraph needs to lead very clearly with who wins and why. And it's got to be clear to the reader what happens. And I know all three of us have pulled our hair out at various times reading essay answers in which you read the third paragraph and you go, I have no idea what this writer is saying. I don't know what they think should be the result because they're so afraid to give a result. Don't be afraid of it. There's not a wrong answer in an essay. There's only the way you reason through and show through it. And when people hedge so much, they get in trouble, right? And then things break down pretty badly. So I think using a direct style is going to make a difference. Brianna, I know you've experienced that as a writer, right? It's just important to get straight into it.
It absolutely is. And I think that the more words you put onto that paper, the more confused you're going to sound. So if you get straight to the point and you make those words count, you're going to be clearer, more concise, and that follows into what Judge Dawson was talking about with don't waste time. Don't waste anybody's time in your writing. Every single sentence in paragraph 3 for me always said X wins because, Y wins because, and getting myself to that point. And so it became second nature because that's the one sentence you cannot forget. I wrote it down first. I still use FLA in all of my legal writing. I have been told by clients, judges, peers that my writing is superb to other attorneys in my area that I work with. And I strongly believe it's because of that FLA structure and it's very direct and everything that Judge Dawson was talking about. It's important to, I like the idea of speaking in present tense. I do it in my writing now. I didn't think about maybe doing it on the essay.
It's much
So-
stronger. It's much stronger. And it's a subliminal effect on the reader that you are an expert. And when you come into court, you are an expert and you need to be an expert. And I cannot stress more how important it is in this exam to be ethical with the facts, ethical with your recitation of the law and your application of any case law that you put, ethical with the opposing party that you're not going to be supporting in your final paragraph. You still need to be highly ethical and highly professional, which is why we're telling you to come at this as a professional, as a lawyer. You come at this exam as a lawyer, not as a student anymore. You're not in school anymore. You don't get to wear the t-shirt and the shorts to the exam. You come as a professional and you act like a professional and you speak like an expert, even if you're faking it till you make it. You come in there with a lot of confidence, and you bring that confidence into your writing when you use the present tense, I think. The other thing is what Brianna said about making sure that you have enough room and have enough time to get to your conclusion. I love what she suggests about writing that first, and then you can always bring it back. But that's why I suggest that the headings should be words that kill and words that lead the bar examiner where you're going, because when you are through writing that essay and you have another 5 minutes, you want to go back and make sure your paragraph agrees with your heading and supports your heading, and that all of your headings have had a full recitation of all them.
Yeah, it's great. There's a lot of wisdom there, folks. That view from the bench is really valuable. Thank you very much for that. Appreciate so much, Brianna and Tracy, you being here. Thank you, June, for being on the chat box and putting all the links out. If you need links to any of the things we've talked about today, bar maps or the video nutshells or the personal writing workshops or the upgrades, just let us know. We're glad to help you out with all of that. And I would say as we wrap into this now 4-week period before the exam, don't panic, just keep working steadily. 4 weeks is still a very long time, isn't it? There's
Yeah.
a lot ahead of us, and just keep working. And we are here to support you in all that you're doing. So thank you all for being here. Thanks, Brianna. Thanks, Tracy. Thanks, June. And we will see you all again next Wednesday. Have a great study week. And with that, we'll say goodbye. Take care, everybody.